Mr. Šešelj, I didn't really understand. Could you make something clear, please? If by chance all these conditions you mentioned are not met, you are asking us to directly go to the final judgment? Closing arguments from the prosecution and yourself? Is that what you want? Or are you asking for 2 years to prepare for your defense case? I didn't understand this. I believe that all this is a bit contradictory. So could you make it clear, please? What exactly are you asking for? If these conditions are not met, do you want to directly go to the procedure for the final judgment? Or do you want us to give you 2 years? Please make it clear.
Madam Latanzi, the interpretation most likely was either incomplete or inaccurate. I said to you, if you meet all of these conditions that are properly grounded in law, then I need the following. This is what I'm seeking. Now, what you will approve out of that, 2 years, 100 witnesses, and 120 hours, that is to be seen. So I stay within the provisions of the statute. I ask these things, and then you rule on them. And later on, I can appeal if I'm not satisfied with this. However, these 5 matters that I mentioned earlier directly endanger my status here and my ability to present my defense case. I have to know why 6 years ago the prosecution wanted proceedings to be instituted against me. I am so curious, I can't sleep. I have to know what were the documents that the UN cavalry seized from me 6 years ago. I have to know what those documents are. And also, the status of all of my legal advisors and case managers needs to be normalized. 2 of them visited me recently, Nemanja Šarović and others. They paid travel expenses for 2 legal advisors, but not for 2 case managers. I have my case manager. My case manager is in charge of my legal advisors. So what am I to do? I will not allow anyone to humiliate me. And even though I may have humiliated registry enough so far, I will not allow them to do the same to me. So these are my requirements without which I will not be presenting my defense case. Unless you meet these requirements of mine, which are completely justified, that I want you to set the date for my opening statement. I will not deny myself the pleasure of those 4 hours in the courtroom. You can do that even before the end of May. I'm prepared. Just don't do it next week. Don't schedule it next week because my wife is coming to visit me and I will be caught in crossfire. So after the following week, you can schedule a day for my opening statements. And then after that, we can proceed immediately to closing arguments. Unless I present my defense case, I will not be filing my defense final brief either. So that will additionally shorten the time. And if that suits you, then very well. Perhaps whether you will be able to convince the public that this was a fair trial is another matter. That's your problem. I know that the entire public will consider these requirements of mine to be fully justified, and no lawyer can challenge what I have just told you. And then it's up to you to see what you're going to do.
Mr. Šešelj, you have made a number of requests. The trial chamber will meet and deliberate on this. As of now, I cannot give you any answer. But they're simple things, however, where you can have a clear indication right away. Obviously, you challenged this chamber's decision on legal grounds. You're, of course, entitled to this. And you can appeal this decision made by the trial chamber. This is a right you're entitled to, and maybe the appeals chamber will disallow this trial chamber. Then,
by your leave, let me tell you right away, I will not be filing an appeal. because you know that those judges from the appeals chamber were always much worse than you, so there's no point in filing an appeal. I will be appealing the trial judgment, but as for your interlocutory decision, I will not be appealing that.
Very well. Then a few years ago, I was a pretrial judge for your case, which is absolutely right. I remember that chamber made a decision because by error the prosecution had sent documents that you were not supposed to obtain. Now, I don't know how the prosecution works, and it's quite surprising. And the OTP wanted to get these documents back because you weren't supposed to have them. And the pretrial chamber had decided to retrieve them. It went with a representative of the OTP as well as a representative of the registry to retrieve the documents. And now you're saying some documents were taken from me and I want them back, but I don't know which documents you're talking about. We'll take a look into this. Then you also said that there was a procedure for contempt of court. I have no recollection of this. It seems that you're saying that there was no decision, or a decision was handed down and it wasn't disclosed to you. I don't know. I'm going to look into this too, because I don't see why anything should be hidden from you. Now, regarding financing,
may I explain? The decision was made, but both the motion and the decision were ex parte. And I was informed in only one sentence that there had been a motion and that a decision was made rejecting the motion without ever explaining to me what it was all about.
Very well, now I understand. There was an ex parte request made by the prosecution and it was dismissed. And you were told about it. So you're seizing this trial chamber with this issue? Very well. I will look into this with my fellow judges. I really don't see why anything should be hidden from you as of now. Now, let's go back to finances. You know that the trial chamber has greatly worked in this direction. I undertook myself, against the will of my fellow judges, to do much things. I called upon the administration of your own country to know exactly what was your tax situation. The Serbian administration, the administration of your country said that it had disclosed all this information to the registry. Then the trial chamber started a procedure. We rendered a decision. The registrar was very unhappy with this decision and appealed. And then the appeals chamber, in its majority with 2 dissenting judges, decided in our favor, which is why it was decided that you would be financed up at 50%. And now you're asking us for hundreds of thousands of euros. You gave us the exact number, the exact figure, but we'll deliberate among ourselves to see exactly what we will do. We'll take a look into this. But I must say that personally, I never tried to play hide and seek with you. I've always been fully transparent with you. And this is what I believe. I believe, Mr. Šešelj, that this problem of financing is not a problem. It's because intellectually you're far able to defend yourselves, and you're the best person to know exactly the ins and outs of this case. You have you're like an encyclopedia. You know everything about all this. On a transcript, you find that there's been a mistake in the translation. You can pick it right like that. So of course you can get help, but trust me, trust my experience. You're fully able to defend yourself. So it's not this question of financing is not a real problem. But it's true that legally you're entitled to it through the statute. To tell you the truth, when I was in trial chamber number 2, you filed a motion And I had started drafting an opinion saying that you were entitled to financing and that your associates could be paid back as long as they gave us the justification for the receipts for those expenses incurred. And I still believe, I'm still of the same opinion. But then right when the opinion was about to be issued, the trial chamber changed, and I could not voice my opinion. That's how things stand. This is how things were done. So I've always been very sensitive to this issue of financing, but I really believe, that it's not a real problem for you. But we will render a decision. Since we've been seized of your request, we will render a decision. Because now the case is in your hands. You know that. Just like Judge Otanzi said, she wanted to know exactly what you intended to do. Are you going to present your case? Are you going to prepare your case? We need to know how long it's going to take, 2 years or what. If you want the trial to be expeditious, you can say, okay, I'll make a statement for 4 hours. The OTP does its closing arguments. I do my closing arguments. End of story. We render the judgment. This is one possibility. Just like you could also ask for extra time to prepare, which is what Mr. Karadzic is doing, for example. And then it could drag on for years. But, you're saying you want 100 witnesses, 120 hours? And this gives rise to a series of problems. So, please, if I answered you correctly, as long as all the problems solved are not solved, all the problems you raise are not solved, you will not give us your 65-tur list, right? 65-tur G list.
Da.
Yes. Because of those reasons. Not because that I'm clever. I'm fully aware of that. But that is not going to be the reason for me not to present my case. The reasons for not presenting my case would be those 5 that I have enumerated: regulating the status of legal advisors, funding the defense case, the document for contempt of court from 2005, the documents that had been seized in 2005, and the translation of those 2 books, Ideology of Serbian Nationalism and Roman Catholic Project of Artificial Croatian Nation in the English, because that was the last position of the registry. So those are my 5 conditions without which I will not be presenting my defense case. And it's all based on law. My position is supported by the statute of the tribunal, by general legal principles. I have to be aware of everything that concerns me, what documents had been seized from me and why. I don't care that the prosecution made a mistake. I have to know what it was all about. Perhaps it could be of use to me. And I have to know why the prosecution filed this motion for contempt of court and you rejected it. I have to know the reasons for that as well. Therefore, I will not be presenting my defense case unless these statute issues of mine are resolved, because it makes my defense case pointless. And regardless of how smart one is, one needs to have advisors outside. They need to go out, look for witnesses. They have to draw up witness statements. So there are a number of things that need to be done. They need to assist with proofing witnesses. Do you know how long it took the OTP to proof witnesses? They bring witnesses to The Hague a couple of days before their testimony, and they make them learn by heart, like a poem to be recited, what they need to say during their testimony, and then they check it. My witnesses will be reciting by heart everything they learn in advance they need to say. However, the prosecution will not catch them lying, as I was able to do with almost every prosecution witness.
I have a small correction to make to the transcript. Yesterday you said that Milorad Vojislav was a protected witness. I have the transcript here. Well, the day he testified without any protection measures. He was never granted any protective measures. So maybe there's been a mistake, but he has never been a protected witness. I have the transcript page to prove this. Mr. Markison, do you have anything to say? The interpreters worked wonderfully. They could even translate as fast as I was speaking. Right in sync with myself. And I thank them from the very bottom of my heart. Thanks to them, we were able to finish on time because they interpret extremely fast. So, Mr. Markison, please be extremely fast also.
Well, 1 minute past time, I guess there isn't time for me to say much. Your Honours, the prosecution may submit some material to you on some of the issues that the accused have raised, but the accused, it sounds to me, is essentially seeking that you reconsider a number of decisions you have rendered. Yet he has not done anything to meet the standard for reconsideration. I would suggest that if the accused wants to pursue any of the claims he has made just now, he should file a written submission setting out the law that he's relying on, so that becomes clear, then we can respond to it. And as for the 65(G) ruling that you rendered, he can seek certification to appeal that. Nothing he has said is relevant to challenge your order. He's basically just threatening that he's not going to put on a defense case. It's up to him whether he wants to do it or not. Lastly, I just wanted to say that Rule 65(G) also require the accused to disclose to the prosecution his defense exhibits. So we would also, from the prosecution side, be expecting to receive the exhibits that he will be using. Thank you, Your Honor.
Oui, effectivement, vous avez tout.
Indeed, you're absolutely right. Very well, Mr. Šešelj, do you want to speak again, and then it'll be done?
Yes, Mr. President, I'm not threatening with anything. I'm just fighting for my rights. And the 5 requirements that I made concern my fundamental rights. I'm not coming out with any threats. However, unless these 5 requirements of mine are not met, I will be mentioning them in my closing arguments. I will not be speaking about the merits of the case. I will be addressing all of the violations of my rights since my arrival in The Hague. And in the defense opening, I can tell you right away that I will be mostly addressing this decision of yours and your partially dissenting opinion. This will be part of my opening. I will need about 4 hours, and I will be speaking a bit faster than you. I admire you for speaking that slowly. I could never speak slowly myself, just so you know. Once I'm done with 4 hours of defense opening, unless you enable me to present my defense case, you can schedule closing arguments right away. And I guess that the prosecution's final brief is ready. I guess they've been working all of this time, and we will not need to wait for a long time for their final brief. Or if we do need to wait for a long time, then this assumption that is being floated in the public very frequently will be confirmed, namely that the Hague Tribunal was tasked with keeping me here at any cost for as long until the another round of elections in Serbia is over.
Mr. Šešelj, I can tell you that nobody told me to hold you here, to detain you here. I mean, I cannot speak on behalf of my fellow judges, but nobody would dare to say such a thing to me. I'm a totally independent judge. As you know, I know that there's going to be elections in your country soon. It's a cause for a major national debate, but I cannot factor that in. I mean, if you're here, you heard our decision to dismiss your motion for acquittal. Nobody told us to hold you here. You know that perfectly well, at least for me. Yes, Mr. Markison?
Just very briefly, Honor, I think the accused should maybe be advised that he might be under the misapprehension that he can present an opening statement without presenting evidence. There would only obviously be a need for an opening statement if there actually is a defense case. The opening statement is to lay out what the defense evidence is going to be. So if the accused does not want to file 65 term materials, then we move straight to closing briefs and closing arguments. Thank you, Your Honor.
Finale.
Bien.
Closing briefing.
This is simply not true. I am entitled to an opening statement. Nothing binds me to present any evidence. That's not an obligation I have. Maybe I have no evidence, but I am entitled to an opening statement. And look at another thing, judges, if you have patience. I have, in theory, the right to make an opening statement of the defense and to inform you that I am my only witness and to submit myself to cross-examination. The prosecution is making things up. It's nonsense. Nobody can challenge or deny me the right to an opening statement. And in my opening statement, I will also be speaking about what kind of evidence I was about to present and why I was unable to. And that's what I will do to please the prosecutor.
Bien. Vous avez soulevé.
You've raised points of law, and of course it is our duty to answer to them. But I want to thank everybody, interpreters first and foremost, but also the security officers, all the legal officers, ushers and registrar, and we shall reconvene as soon as possible. The hearing stands adjourned.